There are not more people here than it would be possible to make a really brief introduction, I think. So I'll just start from over there with Andrew, and it's like a two-sentence, who are you? Just do, or is that doable because more people are actually showing up? I'll just skip that.
You're going to get more,
I
Carl.
think we,
Yeah.
I think we just passed the threshold
We're
of
all-
like
you're-
too
everyone's
many
flooding in
people
now.
of actually, which is good.
It's
but,
great.
Yeah, exactly.
Can I stay anonymous then?
You can stay anonymous. It's your right.
Okay, excellent.
To stay anonymous. So, thank you, and everyone, very welcome to this actually first more open session of the Working Group 2 of the Freedom Online Coalition. Now, as some of you might know, some of you might not know, this working group is fairly new. We've only been working on this group actively for, I would say, 2 months. Yeah. So this means that it's really in a formative stage. And this means that we don't really have all the answers. We don't have any answers, as usual. But at least we do have some kind of platform for discussion on a very pertinent issue. As Gustav mentioned, the rule of law is something we throw around a lot. The rule of law as a concept is now appearing in, I would say, any discussion that I noticed even during today's panel that people were making references to rule of law. And we have these words in various UN resolutions that are particular to the internet. The rule of law is actually written into both the UN GGE report of First Committee, but it's also mentioned in the Human Rights Council resolutions, the importance of rule of law online. And I think we're at a juncture where we actually need to start defining what we're talking about. So this working group is actually going to be about actually making some concrete actual deliverables. Many of the phrasings and the words that we've been saying in the internet field and the rights field have been used for a long time. Online, offline, I think everyone knows that one. Human rights online, everyone knows that one. We're now beginning to approach the stage where we are discussing what this actually means. And a lot of work has, many people have been starting to do work on this. There have been lots of talk about principles. We have principles coming from Net Mundial. We have principles from the necessary and proportionate. There are all kinds of principles, but I think what we are seeing as governments is that we are obviously lacking a lot of knowledge about how to actually deal with the concrete challenges and issues ahead, and that makes it really difficult for us to actually go about building capacity in other countries. The other buzzword right now in the global cyberspace arena is capacity building. That was one of the major outcomes from the Hague conference, not least. So in essence, there's this consensus that a lot of countries are now facing a situation where they will need to adopt or update their legislation, their regulation, their institutions to an online environment. That they might be facing the fastest transformational change in their society's history. They're being connected much faster than many of our countries were connected. And the need to do something more than, I think it was the Dutch human rights ambassador that said that many countries are now just basically copying legislation. That's how this is now working. You get ideas that are surfacing in some place in the globe, and concepts and sometimes even whole pieces of legislation are just copied. So essentially what this working group is going to try to aim at is to try to develop some kind of guidance for all of this work. So touching on issues of human rights, the normative issues of rule of law, the discussions that are taking place in the international fora, and making that into something concrete that can actually be used by, let's say, practitioners on the field. I can take, for instance, the Swedish government as an example. Through SIDA, our development agency, we have a substantive amount of work on building capacity in ICT in developing countries. Now, do we have any concrete guidance on what that actually means, on how practitioners should go about and do that? What's good, what works, what doesn't? Not really. And that's even like, we've been doing this for a while, and we still need this kind of guidance. So the notion of actually developing something practical is important. Also, a second goal of this working group, and I'll just hand the mic to Dominique really soon, is to connect this field, the internet sphere, if you will, the broader internet governance world, which we're all in some way part of, to another domain, which is the rule of law universe. Because that's just like human rights were once, looking back, I always use the reference of the IGF. Human rights were not discussed very much at the IGF 10 years ago. But human rights were starting to get mentioned in resolutions and so forth. Now we have the same situation with rule of law. I might, like, who knows, the IGF, who knows if there's a rule of law main session in 5 years discussing how these issues should be implemented. But the important thing is to kind of de-silo this conversation that's going on in the internet field and connect it to the fact that there are people working on rule of law. There are institutions that are working on the issue of rule of law. There's money in the rule of law. There's development assistance in the rule of law. And this needs to be updated for the modern age in some way. So with that, I'm just going to hand over to Dominique for a more broader take on the rule of law.
Thank you. I would like to, as a co-chair on behalf of my agency, the Swedish FOC Working Academy, to also start by welcoming you to this workshop on a highly pertinent and important topic. And also say some words about our agency and explain why we're co-chairing this working group. The Swedish FOC Working Academy is the Swedish Agency for Peace, Security and Development. And we have extensive experience of working specifically with rule of law issues in the field. At the moment, our focus is mainly on the areas of rule of law in connection to public administration, administrative justice, and some parts of the criminal justice sector. So we work a lot we do research, develop tools, provide guidance, recommendations at the field level, but also policy levels. So the aim with this workshop is not only to present our topic, but also very much to test our ideas. And we would very much like to solicit your feedback, your inputs, your suggestions. So after our presentations, there will be a possibility for an open discussion, and we really encourage you to participate in that and share your thoughts. As Carl just mentioned, our working group has so far broadly tried to frame this topic. And we have discussed the challenges, the demands, and the opportunities of applying rule of law principles in the online environment. And our focus is very much on laws, on countries that are developing laws or revising existing laws online, on the internet and states' exercise of powers online, and also countries, states that are how to apply these laws online. And we all know that the internet has, we are familiar with its broader impact on the lives of billions of people around the world, on the economic, social development, on the efficiency of public service delivery, that it makes services more accessible. So it has introduced numerous important opportunities, but with this also challenges, not least from a security and privacy perspective. Rule of law is a principle which has been out there in the international development field for quite some time, for at least 25 years. And it has become an aspiration, an ideal which is supported by people, by governments, by organizations all around the world. So it is recognized as a fundamental ingredient of any democratic society. And it has, during the last decade, become more recognized as an important foreign policy objective and strategy for developing countries and countries in transition. But it has been so far, and it is still, primarily targeted to the traditional areas of governance, which are mostly the traditional justice chain components, the judiciary, within the criminal justice sector, probation, prison services, prosecution, to some extent administrative justice and public administration, and to a very small extent, if at all, to the online activities and to states' exercise of power in the online environment. So when we talk about rule of law, we meaning the actors engaged in this field, us in the working group, we many times depart from the universally recognized definition from the UN Secretary General report from 2004, which defines the rule of law as a principle of governance, which is applicable to all entities, public, private, including the state itself, individuals, also private companies, associations, and to whenever the state interacts with its individuals. So at its core and as a primary purpose, it is about minimizing arbitrary power and holding power accountable. And these rule of law components can be found in other definitions from other organizations such as the European Union and Council of Europe. So all these, and among these components, there are, rule of law is, in order to have an accountable rule of law system, it requires an institutional environment of fair, impartial, objective, effective institutions with oversight mechanism, judicial, parliamentary oversight mechanism, accountability mechanism, possibilities for legal redress, for remedies, but it also poses demands on a country's laws and regulations. And among these demands, we find certain key principles which have been discussed now during this conference, such as transparency, accountability, legal equality, and legality. And although rule of law as a principle is not new, it has been there for quite some time now, applying it to the online environment is fairly new. And at this stage, we need to clarify how these components, rule of law components and rule of law principles, can be adapted to this environment in order to promote conditions for developing a rule of law system responsibly governed internet based on the rule of law, which at the same time safeguards essential human rights, but also promotes all the characteristics of the online environment, meaning operational stability, interoperability, free flow of information, freedom of expression, innovation, openness, accessibility, and so on. And as Carl just mentioned, there is a plethora of different policies and normative frameworks where the rule of law appears, resolutions, but at this stage and at the moment, there is no specific framework or treaty providing guidance on how to regulate freedom online from a rule of law perspective, and specifically from a more comprehensive and systematic rule of law approach. And this approach is needed in order to provide more proactive and constructive guidance on how to institute this rule of law online environment. So our working group has, so far and at this stage, we're trying to frame and to see what rule of law means for the online environment specifically. And to explore its strengths, to see the demands, the challenges, and some of the outputs which we have discussed so far have been to map ongoing initiatives in this field, to develop a set of normative recommendations. But also, as Carl suggested, there is a strong consensus in the working group to have a more practical approach and to develop a set of practical recommendations, possibly a checklist or maybe a guide for actors who want to know more, and then having this multi-stakeholder approach for governments, for organizations, or from the private sector, a guide on how to implement these principles in the online environment. And in order to make this even more tangible and tangible results, we have decided to narrow it down to certain focus areas, which at this stage are freedom of expression, privacy, and data protection. So my colleagues James and Catherine will soon describe some of the key challenges of applying rule of law within these areas. But as we said, after our presentations, we very much welcome you to join in the discussion and maybe suggest other areas or other potential outputs which we should maybe and could look into. Thank you.
Good morning, everyone. Thank you all for joining us. I'm James Losi. I'm a doctoral candidate at Stockholm University at the School of International Studies. I'm also an affiliate at the Berkman Center for Internet and Society at Harvard University. I would like to talk a little bit about freedom of expression today. And harms of freedom of expression are easily visible. These might be exemplified by the shutdown of communications networks, when content is removed from the internet, when an application or service is blocked within a specific country. And recent examples of this might include how Twitter and YouTube were blocked in Turkey last year, and again, just last month for a brief period. It could also be last week when Twitter, Facebook, WhatsApp, and Tango were blocked in Burundi. Some examples can also be the complex filtering regimes of some countries. China is always a top example in how China regulates the internet. But we can also look at how different types of legal regimes look at removing content online, such as the notice and takedown system in the United States for copyright infringement of the Digital Millennium Copyright Act. Now, we idealize the internet as a global communicative space, an area where anyone anywhere in the world can communicate with others. But it's actually much more complex than that, and perhaps it's better if we think about the internet as a regulatory commons, the product of the interconnection of tens of thousands of networks, supporting application services, supporting websites, supporting the cultural production of individuals from across the world, sharing information across jurisdictions. Now, this reality creates challenges for how we actually understand how harms to freedom of expression take place and how we can apply rule of law. And I think there's two areas we can drill down a little further. And these dimensions are looking clearer at governance, not internet governance as a policy space, but governance as the decisions, the process by government and non-government actors, the norms, the practices that govern the flow of information. And the second dimension could be control points, the specific mechanisms through which content is restricted or blocked. This can be the restrictions of physical infrastructure, control over protocols such as tampering with DNS, the domain name service, to block specific websites, using filtering equipment to block access to services or websites, requiring intermediaries to be proactive in removing content, also known as intermediary liability, and also the criminalization of speech. Now we can, by making these constraints visible, we can discuss the decision-making behind these constraints, and thus evaluate whether or not they apply for rule of law, and then think about how can we create a best practices framework for rule of law online and digital communications, which is a goal of this working group. Now again, as I mentioned, the restrictions of communications online is we can say it's prevalent in some countries, less so in others, but it's visible. To use an example from transparency reports, which helps us illustrate what takes place, for example, from July to December 2013, Google received 3,100 requests for removal of content from 112 countries. This included the restricting of defamatory videos in Brazil, which Google complied with, or removing news articles about a police shooting in Austria, which Google challenged because they weren't able to independently verify the content. So when we think about these governance frameworks in which governments might have regulatory frameworks, they might be arbitrary, which can create challenges, or companies might have their own decision-making on how they deal with content, we can start evaluating across these different areas of constraints or control points how content is restricted online. It allows us to investigate beyond the visible and to understand exactly how the decision makes place, and thus better illuminate jurisdictional challenges and the layers of the internet in which control is actually placed. A very pertinent example of restriction of content is when networks are restricted. And this is done in a number of ways. For example, in 2005, following the bombings on 7th of July, police in London shut down communications networks and restricted them for emergency personnel. But this was done for a brief period of 5 hours to prioritize specific communications and only within a 1 kilometer radius of a specific train station. By contrast, in 2011, police in the United States in Oakland, California, shut down mobile communications networks in anticipation of protests in the subway system. While the police acted independently on this decision, the federal regulators, the FCC, started an investigation to evaluate the legality of this, to hold a level of accountability to how the police engage with shutting down citizens' communications at a time of dissent. Other examples of controls of physical infrastructure could be Iran, where a 2013 report documented speeds are artificially slowed to 128 kilobits per second, slow enough to make sharing videos near impossible and pictures fairly difficult, requiring patience of roughly 5 minutes to load some types of web pages. We can also move up these dimensions to think about other ways in which content is blocked online and start thinking about the types of governance decisions that takes place. Burundi, for example, just last week, mobile service, the president, running for his third term, anticipating protests, required mobile networks to block access to websites and services such as Twitter, Facebook, WhatsApp, and Tango, an effort to limit communications and create costs to social organizing. Last year, we saw similar effects, though different regulatory structures in Turkey. Prior to the elections, Prime Minister Erdogan secured a court order for the blocking of Twitter and YouTube. The order against Twitter was about leaks of information and voice recordings of a corruption scandal growing around the Prime Minister. Twitter was able to challenge the order and have a constitutional court overturn it, restoring service. But it demonstrates how the Turkish Telecommunications Agency was able to leverage authority over physical infrastructure and over carriers to control the access to services and websites. Again, last month, we saw another example in which Twitter was temporarily blocked in Turkey. And this was a different case in which pictures were shared on Twitter of a prosecutor being held at gunpoint by militants. And the prosecutor was later killed. And a court initially ordered Twitter to remove the content, and until Twitter did, a few hours later, there was a temporary block on Twitter. YouTube was also blocked for the same reasons. These are cases of different types of content being removed that have also forced us to think about rule of law, to think about what is the space in which we actually approach different types of communications online. I support free speech online, I support freedom of expression, but there's also these difficult decisions of, are there cases in which some types of videos, such as someone being held at gunpoint, might be limited? And that's a question for governance, that's a question for how we apply rule of law. Another area of governance is the decisions companies make. Companies might remove content based on terms of service, the private governance structure over their online communities. Rebecca McKinnon has coined the phrases Facebook it stand and Googledom from her excellent 2012 book, Consent of the Network. Early in the 2000s, Professor Sandra Brayman coined the phrase of telecommunications law as policy. We can also think of terms of service of websites and services as also types of communications law and how they govern these spaces. Important element of this is how companies are tailoring their terms of service to specific contexts, tailoring the terms of service to specific national jurisdictions in order to both meet cultural expectations, but at times engage in private negotiations with countries of what types of contents they remove, at times through these informal agreements. Meeting with hosting providers, they will sometimes candidly tell you how they might receive a phone call from a police sheriff requesting a website taken down, an informal verbal request outside of any legal norms or accountability. But these are the types of pressures telecommunications companies, hosting providers, and websites face. And it illustrates the need to have a framework of principles and how to engage in this. And that's part of the challenge that we have as a working group. How do we evaluate the governance across these specific control points of physical infrastructure, telecommunications providers, of the logical layer of the protocols and communication standards of the internet, of applications and services and websites, and specifically of content? But the opportunity we have is to define a framework that others can draw from. We've heard a lot of great things over these past few days. Rebecca McKinnon noted this morning that there's no perfect model for the internet. Carla Friga, just a moment ago, said commented how legislation is borrowed. Yesterday, our presidential host discussed hardware and software of society, in which law is a type of software. And just like many of us download software and use the default settings of computers, countries also download default legislation, the default standards of how to approach some of these questions. By defining a principles of rule of law, we're able to then influence the default and create a framework that's more respective of rights. There are other things we can draw from. When we look at companies, we have the Global Network Initiative guidance and how governments or countries or how companies should be engaging with governments. Companies should be required and they should be following local laws, but they should also be evaluating the extent that those laws might conflict with international norms, challenge them, require written documentation and court orders before they act in removing content. There's also a deep expertise in rule of law which we can learn from and draw into this new space. There are new things about the internet. There is certain elements in which time and space is compacted, but some of the very things that we might discuss about the internet were once said about past communication services. The New York Times, when the first transatlantic telegraph line was connected, thought that that was going to bring peace because there's no there's no break in time between communication between London and the United States. Similar statements have been made about satellite television. We see now that perhaps some of these are fairly optimistic, but it informs us that not all the challenges we face are new, and the need to learn from the historical past and learn from expertise from other areas and other regulatory comments. And specifically, the opportunity to find these principles to how companies and countries can better shape rule of law online and a structure that respects freedom of expression. The implications otherwise is both not just arbitrary law that are unclear for companies that leave companies as the arbitrators of our information, a medieval standard that could be similar, stylized as feudalism and digital feudalism, but also the reality that countries can also create regulatory structures that grant themselves the authority to limit political speech and dissent, essentially creating architectures of censorship within their regulatory frameworks. Moving forward and building principles of accountability and oversight of freedom of expression through regulatory frameworks allows us to move forward in creating and supporting and maintaining the regulatory commons of the open internet. Thank you.
Okay, so I shall carry on then. My name is Katrin Niemann-Metcalf. I'm a professor and head of the chair of law and technology at Tallinn University of Technology and also head of research at the Estonian e-Governance Academy. And I also work as a consultant on various communications-related issues. And don't worry, that's the end of my CV for the moment. But I will start with a sort of reflection from one of my consultancy jobs, which is very illustrative to what rule of law really is. And I'm working with Somalia at the moment on their telecommunications legislation. And in Somalia, there is no law on telecommunications or communications at all, and there is no regulatory system. It's actually just being set up. And there are a number of companies. There's a lively market with lively competition, lots of providers, actually better choice than in many of the neighboring countries, and it actually works quite well, even to the extent that they have a fund for a kind of a universal service fund, not exactly, but to do sort of useful things in infrastructure, etc. But this is done totally without a law. And going there to talk then about having a law, quite predictably, companies will say, so what do we need a law for? What do we need regulation for? Because things are functioning perfectly. And there's some merit to that argument, but then the counter-argument or the comment to make, or the reason we are there, supported by the World Bank to do this, is exactly rule of law. Because there is one company that's much larger than the other ones, so they're dominant, obviously, and there are a few others, so they haven't monopolized the market totally. But basically, it's really their goodwill that ensures that at the moment it functions. And you never know when that goodwill is going to run out, or when their position is just going to be not as strong as they would like it to be, and then you never know when they're going to pull the carpet out under the feet of the other companies. And actually it was quite gratifying that when I was last discussing with these different companies, that it kind of dawns on them that there may be some point to the rule of law after all. Because what rule of law really is, when we go beyond the kind of more philosophical and nice descriptions of it, or more academic descriptions maybe I should say, it really means that there is a possibility of holding everybody accountable, and there is a system so we know what is going to happen. We never know exactly. We all know that. I mean, we cannot predict how every case is going to end before it's even started, but we know the framework, we know the rules of the game, and we know this is what's going to be applied. And most people who are not lawyers at least, and even many lawyers actually don't really think so much about the law until something goes wrong. And that's when people come running who otherwise say, and this is something we see quite a lot in the, say, the startup field, where companies or young startups, we often say we don't need law and we don't need regulation, but just wait until they have a problem, because then they will come running and say, now help me, help me, help me. And then what is it one can help with? It is law, and it is the rule of law. And the issues that I'm going to mention a little bit about now from our working group's point of view are then privacy and data protection, because as was mentioned by Dominic, we have selected after a vigorous debate in our working group to focus on freedom of expression and on privacy and data protection, simply because we have to pick something. There are also a number of other issues we could discuss, and we will probably come in on a little bit in our discussions in the working group, like intellectual property and so, but anyway, we're focusing on these main issues because we find that they are perhaps the key to implementing a rule of law also online. And privacy and data protection, to just very briefly sort of introduce the issues, privacy is older than data protection as a legal term and as a legal concept. And data protection has sort of grown out of privacy, and this is seen in the way they're treated in many countries' legislations and constitutions. It's also seen by the fact that data protection is actually only mentioned in one significant international human rights instrument, and that's the Charter of Fundamental Rights of the European Union, which is much more recent than the other main human rights documents, such as the European Convention of Human Rights, where cases on data protection are handled under the privacy provision. So the two things are connected. This is relevant because this is really showing us why should we care about data protection? Well, because this is an aspect of the right to privacy, which is a human right. But the fact that they're also a little bit different are significant for the legal picture, and perhaps especially for these situations, as were outlined in the introduction, of going to different countries to establish legal frameworks. And so data protection is more technical in a sense, if we can say that. It is more maybe linked to modern communications. Although I would say, having just said that, I would sort of go back on it a little bit and say that one still should focus on the content of the data and not too much on its form, because something may be more or less sensitive. Doesn't actually matter if you read it on a piece of paper or if you read it electronically. It's still the content that should matter. And it is very common that countries forget that a little bit, countries, organizations, and so on, focus a lot on the form because it appears more worrying to have electronic data. It's sort of less tangible. It is not totally irrelevant to make the connection, obviously, with technology, which can be seen also if we look at sort of history of data protection. Those laws specifically mentioning that are pretty much as old as information society, because there are so many more ways of making use of data with the help of technology than without it. And much data that actually the information may be out there, but we could do nothing with it until we had the electronic means to deal with it, have created lots of new situations, and these are the ones that have lifted this issue up to a different level. And this is what then needs to be focused on and understood in the legislation. And another new issue then directly related to this technology aspect of it is that we can actually use technology to help us in this situation. It's one of my favorite chicken and egg questions, is this what should come first, the law or technology? And it may seem obvious one way or the other, but as soon as you start thinking a bit more about it, it becomes very complex, because we heard also this morning about how to try to think about the risks and not let technology develop too much before we sort of start taking some actions. Makes a lot of sense. On the other hand, can we regulate technology before we really know what it can actually do? Because then we may either create something which has loopholes, or we may hold back technology developments because we've regulated it too much. On the other hand, if we make regulations that are too vague, they may serve as nothing. So there is no answer, basically. But we cannot, when we go to work in different countries, or when countries are supporting developing and transition countries, you cannot go there and say, sorry, there's no answer. So, you know, that's not what people want to hear. So you have to give some guidance, you have to help to create a framework in which these answers can be found. And this is where said one can use technology sometimes to help. This is something new. This is something which also from the rule of law viewpoint, we have another aspect which hasn't really existed before. I'll give you a very specific example from my own country, Estonia, where, as you probably know, we're very leading on e-governance. We basically do all our governance electronically, and we have what we call integrated databases. We call them the X-Road, which means simply that all public and a number of private databases are integrated so that you do not have to ask for, if an authority needs information that's held by another authority, you don't have to ask for it, but you can access it directly through a web, which means that everybody has control of their own database, so we don't have a mega database, but you can just find those channels. So as an individual, also I go to one specific portal, and there I do everything I need to do with the same codes and passwords and so on. Obviously creates data protection challenges. And one of the ways that technology can help is that every activity when some authority accesses data leaves a footprint. So I can see that if I open my portal on a very simple address, Eesti, which is the Estonian name for Estonia, .ee, I slide in my ID card, my code, I open it, and I will immediately see that, the tax office has been looking here 3 times during the last few weeks at my data. It makes me very worried. So usually I may understand what's going on, and I'm maybe less worried, but if I don't know why, I can ask, and they have to answer. They have to say why have they looked at this? Not only do I do this, but the Data Protection Inspectorate has a possibility of monitoring how data is being accessed. And if there seem to be some strange activity, for instance, some data is being accessed very much, which doesn't look to be exactly in line with what you can see that authority has done, they will also contact the authorities to find out what's going on. And so, because the key is that when you have data and data protection rules, you create systems by which authorities have a right to access certain data, and that has to be done. So to come again to this issue of the sort of rule of law and how to help with what to do, rule of law doesn't mean limiting. It means just creating secure systems for doing things. So there may be lots of good reasons to use data, to make new use of these technologies that exist to make governance and other things more efficient, but there has to be a proper framework in which to do this. And then this kind of use of technology can be very helpful, because that way perhaps we have eliminated some risks that we've created also through technology. And then the legislation will come in to then address remaining risks and so on. So there is all the time this kind of balance between the different issues, which is new in our more high-tech society. But what we still then need to focus on very much, and that will be my last point to leave time for discussion, is what also in the other workshop that I had the benefit of being on the panel on yesterday, we talked about surveillance and issues related to that. And it was said by all of us in introduction to the panel as well that there is a need for things like surveillance. We do have situations in which it is legitimate to limit people's privacy and to use information in ways which are not seen from an individual viewpoint, which might infringe my rights, but there may be good reasons for this. So it is again why we need the rule of law, is because what rule of law means is to have systems of accountability and systems, and this was already mentioned by my colleague as well, systems, institutional systems and other systems to really enforce the proportionality of any limitations, to look at whether this is necessary in a democratic society, whether there is a good reason. So what we're trying to do also in this working group is very much to make this balance and to make these systems and these proportionate ways of dealing with the challenges. So looking at it, and that's also that'll be my very final word, that this is how perhaps looking at it from just a human rights perspective is a bit different than what we're looking at it from the rule of law perspective. I mean, the two things are obviously very connected. Rule of law is a way of enforcing rights, but it is a little bit more or a little bit different than just enforcing rights. Thank you.
Thank you, Katrin. I'm going to open up the floor for discussion. I just wanted to briefly make my own reflection now while I have control of the mic. Also because I love hearing my own voice, and this is great. I'll try to avoid the plosives. I think one of the issues that we often might not be totally aware of is how, I'm not going to claim to be an expert on this, but how many of the internet issues look from the vantage point of a country or an actor that has a very low capacity. I'm going to take an example which is really pertinent now, which is an issue that we're not dealing with in this group right now, but which we might touch on, I know people have raised it, is the issue of online terrorist content. Now, this is like one of the major issues in the on the international diplomatic arena right now, and it's a question of that combines many of the actual like sub issues that are normally discussed in the internet governance framework. It is a discussion about content removal, about police, judiciary power, it's about surveillance, it's about privacy, it's about freedom of expression, it's about all of these things. But it's a very concrete issue. And it's an issue that's being discussed now where countries are not only mandated by Security Council resolutions to take action, but they also lack capacity and guidance on how to actually go about and to deal with this problem in a way that respects fundamental human rights. And that's where we are. Like that's where we need to go beyond the common rhetoric that we are that we are used to push forward. I'll just make a very brief reflection on how urgent this issue is as well. I just this morning saw a report from our New York office from an open debate in the Security Council on the role of young people in combating extremism. I think it was an open debate held yesterday in the Security Council. And one of the bullet point was how the internet enables terrorism. And one of the points that were raised by some countries in this debate was the need to ensure that ISPs can block content and users. So this is like the advice that you'll have the same countries that signed up for the Human Rights Council resolution talking about freedom online, offline, and rule of law. Some of them are also now, given that that was a consensus resolution, you also now have the same countries also in the Security Council briefing saying we need to make sure ISPs can cut off users and content. So that goes really into the how. Because that is now the issue. Like, how are these countries that are attending that Security Council briefing going to go? What guidance are we giving them on how to actually deal with this particular problem? And that's really the focus of this working group is how to go beyond the rhetoric that the more shallow rhetoric. So. With that, I'll just open up for discussion. I hope there are a lot of people who want to. I see Andrew over there, and that's a lot. Wow. All right, I'll just start with Andrew. Could you please hold your hands up? I'll try you. I think it was like this actually, so it's very very easy. You know that now. Okay, we'll just.
Thanks, Carl. I did a lot of rule of law work with access to information and free expression a few years back when I was with Article 19. So. I've thought about this a bit. I think, obviously, the working group needs to find its value added and go beyond the kind of high-level norm setting. And I don't think a global treaty or discussions is the way to go for, I hope, fairly obvious reasons. So when we reflected on how to promote and support countries developing legislation, we looked at really three angles. One was legislation that placed positive obligations on countries or agencies to promote human rights or take into account human rights as part of their normal operation. So if you had a regulatory authority of some kind or it had some positive obligations. Secondly, an examination of the actual regulatory environment itself, and I think the particular challenge here is we heavily regulate telecoms, we don't really regulate internet services, and yet we're now dealing with a converged environment. So we regulate telecoms, we don't regulate Skype. And I'm not saying the answer is to regulate Skype, but there is a real challenge about building a regulatory environment in a converged communications climate that can deal with issues like content restrictions, net neutrality, interoperability, copyright, and so on, which is how speech is actually being regulated in many, many countries in the world. Not formal repression, but through these other mechanisms. So looking at model regulation is good. And I think the problem there is I don't think you'll find great models anywhere. I mean, I don't think anybody knows how to do this. I don't think Europeans know how to do it, for example. The US has kind of outsourced its regulation to Europe, and Europe has outsourced its entrepreneurship to the US, and everybody else is wondering which way to go. And so I think there's a big challenge for the working group there. And the third is, the laws that regulate the conduct of agencies and governments themselves, that place restrictions on them and what they can do and how they deal with this environment. So I say 3 areas to look at: positive obligations, the development of a converged regulatory environment, and thirdly, the laws that regulate and control government and public agencies. That would be the framework, I think, that I would start to look at the kind of issues you're beginning to raise.
I'm Thomas Heinutzi from Austria. Well, it's a very interesting project, so congratulations. You have quite a lot of work on your shoulders. And my question would be, the first question, you mentioned as a possible end product, normative recommendations, checklist, a guide on implementation, and best practice, and so on. They are all going to the same direction, but still very different landing points. So what exactly is now the objective? What should be the end product? Is it Mindest standards? Because I join totally what Andrew has said. I think it would be very difficult to have a model law or something like this. And there are variations in the legal traditions and all this, but certainly there should be certain Mindest standards. And then the second question is, you also said that a number of countries are just copying legislation from other countries, and we had it also yesterday in the very interesting session of the Internet Jurisdiction Project. There seems to be a real need for a repository of national laws. So yesterday we touched it from the angle that smaller companies that operate, of course, in different legal environments, they don't have necessary enough legal knowledge about the smaller markets and so on. So my question perhaps goes more now to Katrin. Is there already such a project somewhere to just collect the different legal legislation of countries on these subjects that you touched upon here, for example, the 3 main areas you want to delve into? Because that might be useful if it could be university or whatever, if this would be available somewhere on a website. Thank you.
Let's take a few more questions before we go to Katrin. Let's see who was, I'm just going to, I know we were doing, yes.
Just to add one point, could
you introduce yourself as well?
Is it on?
Could you introduce yourself?
Oh, Gene Kimmelman, Public Knowledge. To add to your complexity, it seems to me beyond the laws and whatever models, you have to also take into account the interaction with trade agreements, because a variety of the legal attributes you're talking about are being negotiated beyond national boundaries. And so just to think of, again, if there's a model even of best practices or practices at all, that ought to be taken into account because it can totally nullify the national laws.
So, Bertrand Lachapelle, Internet and Jurisdiction Project. One thing on what Carl Friedrich was saying is that it's becoming a power struggle among the different ministerial departments in each country. And the balance is shifting at the moment between the freedom aspects and the security aspects. The point I wanted to highlight is when we talk about the rule of law, there is a natural reference framework, which is the national territory and the national laws. And all the components that you describe are particularly adapted to the national territory. And I take one example, which is appeal mechanisms. Having a recursive judiciary system is wonderful. The challenge with internet aspects is that we are dealing with this at a transnational basis. And developing appeal mechanisms at a transnational basis, to take just one example, is a huge challenge. There will not be an international internet court. Where do you go when you have something that you want to appeal, when it's a decision by either a national court or a private actor? And here I want to suggest something that is growing in my mind since the last 2 days, basically, which is a shift of perspective. We have a very government-centric perspective when we talk about those issues. I would argue that in a certain way we should have, or test, at least as an intellectual exercise, a platform-centric or a cyberspace-centric approach. Because the challenge and the fact is that today when we say law, a large part of the rules are being established willy-nilly by the private operators. And it's not only the big platforms. It can be a very small platform that has its own terms of service and accepts some content or not. In addition, public authorities are asking the private actors to play the role that they usually were playing. And people are talking about the right to be de-indexed, where fundamentally a court at the European level asks a private operator to balance privacy and the right to know and the right of information. Countries in the surveillance environment are now asking the platforms to do an active monitoring of their environment. And so not only are the private actors given the responsibility or the burden of doing some things that used to be public functions, but at the same time, when they're regulating their own spaces, when you think about it, and I'm pushing the envelope a little bit, they are combining the three functions of the legislative, the judiciary, and the executive. They set their terms of service, which is a legislative function for the digital space. They do the judiciary when they receive requests where they say, yes, we accept them or we don't. And they do the executive by implementing the decisions that they've made. It's not a criticism, it's a matter of fact. And I think we need to help those actors and take into account the fact that this is the current situation we're in. And when we talk about the rule of law, it is everybody's interest, including the companies and the governments and the civil society, to think about how those terms of service embody very private rules, but also public order elements, whether they are substituting in a certain way to the whole legislative and judiciary process, and how to make sure that when we talk about the rule of law and due process in general, we address it on those transborder spaces that are actually the companies and any website operator, as a matter of fact. And again, it's not a criticism, it's just to try to shift the perspective and look at almost internet jurisdictions rather than the combined jurisdictions of the national territories.
All right, we'll respond to a few, and then I'll just continue like that.
Okay, just a few. I'll be very quick and make a few comments. That as far as the repository or direct question, there are a number of organizations and so that are doing things like that, or universities, so gathering laws from different countries. So, but the problem is that none of this is in a sort of official or formal capacity. So as a user of these, one doesn't know if you can really rely on it, you know what I mean. So it'd be a good job for the new UN rapporteur perhaps to deal with. About the norms, whether we can use norms of one country in another, and so we discussed that, and a number of groups discussed it, also the one I was in yesterday. But I think there, just very briefly, I think it comes down to the level of abstraction. If we have a higher level of abstraction, if we look at it more normatively, I think it is quite possible to use principles that can apply in different countries, even if they are from different jurisdictional systems and so. But I think this is actually one reason for doing something what we're doing, to get away from trying to use other countries' laws as models. I don't like that at all, very much working with these kind of issues myself, but using principles and norms that derive from somewhere, that can be very useful. One of the big challenges is definitely the privatization of this whole system, where we do have incredible tasks carried out by private companies. We have a private company deciding what's sort of ethical and suitable or not, and so on. Google I'm thinking of now, and they may do it very well. They have people who may be doing a perfect job, but it's a little bit funny, at least if we think of it the way we're used to thinking of the role of different actors in the sort of world, that private companies are having such important roles. But this is something which just has to be taken into consideration, because that is the reality, and I understood your point like that as well, that this, like that's it, and we're very aware of it. So, and as to the first point made by Andrew, I think you've been doing secret surveillance on our working group meetings, because that's exactly what we've been discussing. How can we do our value added? So.
So when we look at, I think there's some good comments here on the different types of issues that do shape the flow of information. Trade agreements are certainly one governing structure. Terms of service are certainly a governing structure, and one that I mentioned. And I think that, I mean, we're looking at the challenge of complex interdependence between states, as well as the role of private actors in mediating the flow of information between those states. I mean, that's why I suggested that looking at different dimensions allows us to evaluate where governance takes place differently. The national state is not eroding, but it might be shifting into the role of governance. There's still importance of how national telecommunication structures are regulated and the roles those have in the flow of information, and particularly the normative environments. I just want to mention one comment on that, and that the representative for the freedom of expression, both for the UN and for the OECE, said the kill switches and shutting off of physical infrastructure and internets is never compatible with human rights. That gives us a clear guidance on what should not be happening on the national level. And I think that evaluating that in terms of how states are outsourcing authority, which has been a centuries-long history, everything from the early days of copyright, when Britain outsourced censorship as part of the patent system, to the outsourcing of certain types of authority through private land ownership in the 18th century enclosure movement in Britain, 19th century in Sweden. You see an outsourcing of authority that continues in how we see the development of cybersecurity today, and dependency on private actors for certain roles. So as I mentioned, we have this complex interdependence of how different actors are governing the flow of information. So looking at different layers and the ways decisions happen at different spaces allows us to map that space more accurately.
And I will just continue with the people who were not, I think it was sort of there, and then there, and then there, and then there. So that's 4 now.
Sorry, thank you very much, and it's quite interesting to hear the debates. My name is Joseph Kihanya, I'm from Kenya, and just to perhaps take off from where he left off on the trade issue, I must say that in our environment, we are trying very hard to look at the rights perspective. We have a new constitution, and the constitution requires that we respect privacy, and it's a bit interesting to hear that perhaps we shouldn't be looking to borrow too much from other jurisdictions, but we are trying our level best, given that if we are looking at data protection principles, the only ones we can borrow are perhaps maybe from Australia or from the United Kingdom, given that they share our own history and the common law system. And we also look to the Budapest Convention, because we know that for trade purposes, if we're going to look at the outsourcing industry, we have to meet the adequacy protection minimums. And for this, we are hoping that perhaps as we go along, this is the best we can do under the circumstances, given that our courts have said that the government must pass certain legislation, and we are looking at our constitution in order to be able to implement it. And we have to do with what we have currently, what is pertinent in Europe. We know that, for instance, the Budapest Convention is under review. And perhaps for me, and the question I would want to ask is, what is the working group's take on the perception in the public that they anticipate that with the advent of technology, their privacy is going to be infringed on? This is, I think I read about a survey that was done before the review of the Budapest Convention. People were asked in Europe, and they said upwards of 30% of them expect that some aspects of their privacy is going to be infringed on in relation to the manner in which they relate with technology. I read something about it last week. Some people say when you relate with technology, upwards of 40% of the surveyed people say that they anticipate that there's going to be a loss of privacy in relation to this, and how you deal with that perception, and how it is that the data protection principles are going to be applied, and the right to privacy as a general right is then applied in relation to that. Thank you very much.
So I have a few comments. I will try to go through them fast. And so the first is actually adding to Bertrand on how platforms are jury, judge, and executioner. I think it would be interesting for you as a group to also look at what does it mean if public spaces actually shift towards platforms. What does it mean if the public space is not the square anymore, but is Facebook? What does that mean for human rights, and how should they be upheld? Can we look at some things that happened in physical spaces? For instance, the right of way, which we saw happening when lots of more spaces became private. In Great Britain, for instance. So that is one point. Another is getting back to governments and the rule of law. I think we came, as democracies, came a long and bloody way to where we are now, literally. And it is great that we have these kind of principles, but at the same time, I think what we're losing is a very important notion that was, when we started with these liberal democratic states, was very well in every kind and type of legislation, and that is a basic philosophical distrust in government, which is, I think, needs to be more articulated than it is by just saying accountability. Because what we see happening is under the notion of especially terrorism, see a lot of laws that actually give unfettered powers to governments without providing this kind of basic norm of distrust. So I think that should be something you have to look out for. And actually, I find this very, very concerning, because I don't want to Godwin you all, but we've seen this kind of, because of how the world is today, we should actually get more power to the government so as to protect you. We've seen that before, and the outlooks of that are not so very bright. So another thing is about the question, what was first, technology of law, or law, or what should be first, technology of law or law? I think that is very much power-bound. To like taking the notion of rule of law, and that concept would say that any kind of new technology that could be used by a power like a government should actually go through like a legislation before it's used. So you can't hack into other people's computers with before there's any regulation or law about it, if you should do it anyway at all. But just to give an example. The other way around, we should make sure that laws are broad enough so that they are not like bound by technology so much that they actually kill innovation. So, and I think that could be done because we have a human rights framework that has been around, that I think is broad enough to talk about all of these issues. And technology is not so, the internet is a great place and it's very innovative, but it is also not so much different that that same framework of human rights doesn't apply. The third point is, or was it the fourth? The third point is education. We have a large gap to breach between technologists and policymakers, where policymakers, a lot of policymakers still feel comfortable saying, well, you know, I know nothing about technology, but, well, I can make some policy. And on the other hand, technologists are like, well, you know, I'm just implementing technology and I don't care about what the effects of it are. And I think both is really detrimental to protecting human rights. So I think there's a large gap to bridge. And I think civil society is also to be held accountable to make sure that they understand this and engage with technology as well as with policy, and not just one of them. Going back to, oh yeah, my last point would be, well actually it's not a conclusion, it's a last point, but the last point would be looking at the international framework. I think as it could very well be that, well, the online is actually enabling human rights violations, and the next genocide could very well be, or the one after that could very well be one that is like aided by the internet. That we should actually really look, or you should actually really look as a working group, how the emerging norm of the responsibility to protect could be applied in this framework. That's it.
Yes, hello everybody, I'm Paul Fellinger. I'm the manager of the Internet and Jurisdiction Project, and I also have the honor of being part of the working group too. Just I cannot agree more with all the elements that all the four speakers raised in the beginning, that this is a great opportunity to actually frame what the rule of law means in a 21st century that is digitalized and that is based on the internet basically. And just in terms of methodology, I could see three sort of stratifications that could order a bit the work, because it's a very vast area that transcends into different policy issues. So I would say one is the national and the cross-border. That I guess is obvious, and the various speakers raised this. So what does it mean to have the rule of law in terms of national laws, designing new national laws, applying it in purely national context, which still exists also on the internet. But what does it mean in cross-border context when either you have cross-border interactions, or as we discussed yesterday in the workshop, or you have operators located in foreign jurisdictions, servers located in foreign jurisdictions, cross-border data flows. What does this mean? Because this poses really new challenges. The second element is what does it mean from a substantive point of view and from a procedural point of view? So what does it mean if you pass new laws in terms of the content of those laws? But what does it mean if you apply those laws? And here again, the main distinction is the national and the cross-border dimension, because especially the cross-border dimension poses completely new challenges, and we do not yet have the answers to this. And the third point is in terms of thinking about possible outcomes. From a normative point of view, there's a possibility to structure it across according to two buckets in a way. One is how existing high-level principles, human rights principles, and so on and so forth, should be applied on the internet. And the second bucket, which is even a bit more innovative, is what are new internet-related principles, because there is a body of new emerging rule of law-related norms on the internet of how you apply, for instance, your national jurisdiction in cyberspace, and what are the procedures for this. So there's a body of emerging norms, and I think it will be also a great opportunity to document them. Thank you.
And I think the final speaker on the speaking list over here. Yeah.
Hi, Michael Mo from Amnesty International Hong Kong. Two quick points. I would like to respond to James, like in UN Human Rights Council's Civil and Political Rights Committee, they have issued a general comment number 34, which directs about the freedom of expression. And in some paragraphs, they're directly targeting online freedom of expression, those principles, or how states should behave when they're when those committee members trying to assess countries' report periodically. And I think the paragraph 43 would be very great for the working group to concern, which is trying to say that any restriction on the operation of website blogs or any other internet-based electronic or other such information dismantling system, including blah blah blah, should be are only permissible to the extent that they're compatible with paragraph 3 of Article 19 of ICCPR. So there might be a principle or guidelines already out there that the working group might be referenced to make a checklist. And the second point I would like to make is about the surveillance exports. It feels like it's kind of like the same problem of arm trade, unlawful arm exports. So I don't know whether it would be, a lead to push something for, a international law, something like arms trade treaty, to regulate, using state power to regulate unlawful surveillance exports of private firms.
Yeah, that's a major issue that's being debated in UN. The prospects are not looking good for any progress on that issue right now, that's for sure, but it's really an ongoing discussion. I'll let, were there any more questions? There were actually two. Could you make really, really, really brief comments? And I mean really, really super brief, because there are nervous hosts hovering outside the door wanting us to close. So I'll first go to Axis.
Actually, it's more just an announcement, and just to table the implementation guide for the necessary and proportionate principles, which would be great for the working group to consider, because we've talked about higher level kind of principles. This is like an implementation guide that goes step by step through the process, and I think it really is about the application of the rule of law in a transactional sense, so I'd like to officially table it.
Thank you. And the final statement.
Actually, hi, this is Ephraim Kenyanito, also from Access. I would just want to raise that, like he mentioned about principles and the necessary and proportionate principles which have been endorsed by over 400 organizations and various individuals, draws a lot on language from the UN and these principles, and this guide also draws a lot from those UN resolutions. So yeah, I wanted to mention about that. Thank you.
Thank you. Can we have, I don't really know if we have time for actually concluding remarks. Does Catherine want to say a few words? 2 or 3?
2 or 3, really, because mostly very useful suggestions to our working group, so I won't comment on all of that, but I'll just pick up on the one thing which was maybe a little bit more like a question, which was about the public perception issue, and we're definitely thinking about that all the time, and I think it is an absolute key when it comes to privacy, and this is also something which is a challenge. It's something which is different to the way people understand the data protection. So that's definitely something we are looking at. And also to just mention that the situation was referred to from Kenya, that there is a constitutional protection of privacy, but no data protection legislation and principles as such. And this is very common. I would say for very many countries around the world, this is exactly the situation. So one has to elaborate without having this clear legal framework, which makes it even more useful to have these kind of guides and principles. What does that then mean? We have a basic constitutional right, but very little that says what does this mean in reality.
James?
I think closing remark, I think on carrying on the theme of privatization and enclosure, if you go through the Mongolian countryside, you look at both the national parks and the way a common good and public good is used by nomadic peoples. At the same time, you see the implications of petty corruption of wealthy members of UB going out, buying pieces of land, putting fences around them, and illegal logging operations that leave most trees cut down. I think that creates an interesting illustration of what we face with the internet, which is exactly this, which is the implications of dependencies on private operators for what we define as a public sphere. And it does create a very unique challenge in how we approach governance. I think that illustrates why what we're offering with this group does offer a value add in being able to transcend the different spaces between the changing national jurisdictions and the rules of private companies in mediating the international flow of communications and what decisions are shaping that flow.
On to Dominique, your final remark.
Thank you. I just wanted to say very good points and valuable suggestions. So we will feed this into our working group. And some of the points I've noted was your suggestion on integrating, including trade agreements, MLATs, because of course that has an impact on national laws, more national cross-border perspective and a multi-stakeholder perspective, and maybe changing our approach because this becomes even more important in this field, in the online environment, than compared to other maybe more traditional areas of rule of law areas. So thank you very much for all your comments.
Thank you, everyone. We will have to rush to lunch now, I'm assuming. And thank you for staying on overtime and for all the constructive comments. Our contacts are not available on the website, I just realized, but are they, Andrew? They're not, right? All right, excellent. Thank you. Bye. Google us.